Recording in progress.
Welcome, and thank you all for joining us. My name is Derek Bizzo, and I serve as Professor of Practice and Director of the Indian Gaming and Tribal Self-Governance Programs at the Sandra O'Connor College of Law at Arizona State University. I'll be your moderator for today's program. First, let me say we are pleased to present this webinar, Unpacking Brackeen v. Haaland, in partnership with the Native Nations Law and Policy Center at UCLA School of Law. But before we get into today's presentation, we have a couple of housekeeping items to go over. On your screen, you should see an example of the Zoom webinar platform. Depending on what version of Zoom you're using, your actual screen may look a little bit different, but we wanted to point out how to engage in today's discussion. For today's webinar, the audio chat has been disabled. Instead, in order to ask questions of the panel, you'll need to use the Q&A function, which is circled in red on this slide. You'll also be able to provide comments and upvote the questions of others. Also, this video is being recorded and the link will be emailed to you within a week or two. And finally, as a reminder, the link to CLE materials is located in the same email as the link to join this webinar. Now let's get started by meeting today's guests. First, allow me to introduce my dear colleague, Professor Bob Miller. Professor Miller is a William H. Pedrick Distinguished Research Scholar and Faculty Director of the Rosette LLP American Indian Economic Development Program at ASU College of Law. Professor Miller also serves as an appellate judge for several tribal courts and is a citizen of the Eastern Shawnee Tribe of Oklahoma. Welcome, Professor.
Thank you.
Next, allow me to introduce Lenny Powell. Lenny is an attorney in the appellate and Supreme Court and Native American law practices at Jenner and Block. He is one of the two principal drafters of the Tribal Merits Brief in Brackeen v. Haaland, a copy of which is in your CLE materials for this presentation. Before attending law school, Lenny was an elected tribal leader of his tribe, the Hopland Band of Pomo Indians. While in office, Lenny served as chair of his tribe's Indian Child Welfare Committee and regularly represented his tribe in state court proceedings as an ICWA advocate. Lenny received his JD from Harvard Law School, where he was an editor of the Harvard Law Review. Now at Jenner, Lenny regularly represents clients in cases before the U.S. Supreme Court. His Supreme Court wins include McGirt v. Oklahoma, Washington State Department of Licensing v. Cougar Den, and now, of course, Brackeen. Welcome, Lenny.
Thank you, Derek. Great to be here.
Our next guest is Paul Spruhan. Paul serves as the Assistant Attorney General for the Litigation and Employment Unit at the Navajo Nation Department of Justice in Window Rock, Arizona. He received his AB in 1995 and his AM in 1996 from the University of Chicago. He then went on to receive his JD in 2000 from the University of New Mexico, where he graduated Order of the Coif and received an Indian law certificate. He and his wife, Bitta Becker, have 2 children and live in Fort Defiance, Arizona. Welcome, Paul.
Hello.
And last but not least, let me introduce Lauren Van Schilfgaard. Lauren is a member of Cocha di Pueblo and an assistant professor of law at UCLA School of Law. She previously served as a San Manuel Band of Mission Indians Tribal Legal Development Clinic Director at UCLA Law. Before that, Van Schilfgaard served as a tribal law specialist at the Tribal Law and Policy Institute in West Hollywood, California. She received her undergraduate degree at Colorado College and her law degree from UCLA School of Law. Van Schilfgaard currently serves as Vice Chair for the Native American Concerns Committee of the American Bar Association, as a Commissioner for the Lawyers Network Commission of the Center for Reproductive Rights, and as a board member of the Doris Duke Charitable Foundation Child Wellbeing Program. Welcome, Lauren.
Thank you. Thanks for having us.
Of course. Well, I, for one, am excited about today's webinar, and I want to thank our guests in advance for each of your time and commitment. So let's go ahead and get started. Lauren, I was wondering whether you could start us off today by giving us a short summary of the Brackeen v. Haaland litigation and why we're all here to discuss the decision.
Sure. So for many of us, including many of the panelists, this has been part of our lives for a number of years. The reality is that since the enactment of the Indian Child Welfare Act in 1978, there's been a pretty consistent stream of litigation. There is a big pile of cases that are devoted to litigating ICWA. The vast majority of those cases, however, concern how ICWA should be applied, when it should apply to a case, what does this provision mean, when should this apply? This case was relatively unique in the extent it was challenging whether or not Congress had the authority to even enact the Indian Child Welfare Act, which is noteworthy. It's a big challenge, but it also was noteworthy coming 40 years after it had been enacted and was being implemented across states. There is a lot of different scholarship and media and a very well-known podcast around the origin of this case. I highly recommend. But the short of it is that there was a lawsuit that was curated within Texas based on a number of series of clients, including some foster parents, a biological parent, and those lawsuits were joined by the states of Texas, Louisiana, and Indiana, all challenging the constitutionality of ICWA. They were also seeking to invalidate regulations that were passed by the Department of Interior in 2016 under the Administrative Procedures Act. There were 3 specific cases that were listed in the complaint. The cases came from Texas, Minnesota, and Nevada, and involved children from Navajo, Cherokee, Isleta del Sur, and White Earth. And by from, I mean members of or eligible for membership of. As the case progressed, 4 tribes intervened, with a 5th, the Navajo Nation, intervening at the appellate level. This was not necessarily the first time that someone has sought to invalidate the Indian Child Welfare Act. Lots of people throw spaghetti at the wall hoping something sticks, and nothing really ever had up until this point. But this case was noteworthy because for the first time ever, something stuck. In fact, not just one claim stuck. The federal district court found that the Indian Child Welfare Act was unconstitutional for all sorts of reasons. For those of us that remember back with the Affordable Care Act, this happened to be the same courtroom where suddenly the Affordable Care Act was found unconstitutional for a host of reasons. So it wasn't totally crazy, but it was totally crazy. So this case advances to the 5th Circuit, and this is where I think all of Indian country really started putting eyes on this case. What's going to happen? Are we going to snap down this case for being totally bonkers, or are we not? Are we going to entertain some of these? Turns out the 5th Circuit entertained, and instead of going straight to the Supreme Court as the circuit split, that the 5th Circuit is now out of line, holding that the Indian Child Welfare Act is unconstitutional, it goes en banc or to all of the justices in front of the 5th Circuit. And this is where things really went sideways. The en banc apparently didn't know what to do, and we didn't just have a split. We had like a noteworthy, like, what is going on? Law students, like, buckle your seatbelts, 315-page decision with different justices joining different parts, some disagreeing, some only joining this part. I still don't really know where it was stood in that opinion. incredible practitioners and scholars gave as best as they could some like quick last minute guidance, because in the meantime, practitioners are attempting to conduct the day-to-day business of child welfare across the country, including across Indian country. Essentially, we got a variety of different holdings on what ultimately became the primary challenges. Some parts upholding provisions of ICWA as constitutional, and other parts holding other provisions unconstitutional. There were some primary buckets that ended up being addressed in the Brackeen decision. Does Congress have authority under the Article 1? Basically, does Congress in fact have plenary power to enact something like the Indian Child Welfare Act? If they do, are they nevertheless barred under the anti-commandeering doctrine? And even then, does ICWA or provisions of ICWA violate the non-delegation doctrine? Finally, even if Congress has the authority to enact all of the provisions in ICWA, are certain provisions nevertheless in violation of the equal protection doctrine? Does it violate a prohibition against race-based policies, even in the case of ICWA, which is attempting to remediate past harms? And so in this case, especially because of this bonkers en banc opinion, the Supreme Court accepted cert and took us all on a wild ride.
I appreciate that, Lauren. Thanks for the summary of the bonkers procedural posture for sure. Thanks for setting the stage. As we move into the discussion, I thought I'd ask each of our panelists to give us their high-level reactions to the decision. For my part, I feel like the litigation was definitely a roller coaster, and there was a point when we all wondered whether the cart would fall off the rails. So I'm glad to be here today with you all under these circumstances. So for like high-level first reactions to the opinion, I guess, can we start with Bob and then go to Paul, Lenny, and then Lauren?
Well, first off, I'd just say this is a great victory, and I couldn't believe it when the email started coming over the wire, was it on the 15th? I just want to say what I felt when the Supreme Court took cert in this case. I literally gulped. I thought to myself that this could be the end of Indian law as a separate discipline, and that it might just be, with the 6 conservative justices that we talk so much about and are concerned about, that Indian law could become just affirmative action, and there'd be almost no room for Congress to enact laws such as ICWA. Then I got over that pretty quickly, but I told many people that the best we could probably hope for is an affirmance and 2 or 3 or 4 of the provisions of ICWA going down to the anti-commandeering principle. So that's where, just to be real brief, Derek, but that it's just a fabulous victory and a 7-2 decision. After hearing it's a win, then you look, is it only 5-4? And it was 7-2. So it's a fantastic news for Indian country, and congratulations to those online that litigated it and everyone else that was involved.
Yes, I'm next. I'll keep it brief. Astonishing, astounding decision, but room for more. And I'm sure we'll be talking about the more as we go through it, because plenary power to some extent has been upheld with these sort of threatening limits that they are mentioning but not specifying. 10th Amendment, as Professor Miller notes, held not to invalidate these provisions of ICWA. Sigh of relief, sort of exhaling of breath being held for years, but what does it mean? We'll talk about it. Thank you.
I think I don't disagree with anything that Paul just said, but my takeaway is a bit more in Bob's camp than in Paul's, in the sense that, I am focused on the positives, and I think there are so many of them to emphasize. I do want to quickly note that Keith Harper at our firm, who sort of led the litigation effort on behalf of the 3 tribes we represented, General Block, since 2018, wishes he could make it. He had a vacation planned to be out of the country. We didn't think we'd get the decision quite this soon. And Ian Gershengorn, who argued the case for the tribes in November, also had already scheduled a conflicting webinar on a totally different, non-time sensitive topic, but unfortunately he had committed to that, so he also couldn't make it. But they both wish they could have joined this wonderful panel. So, I think that this case is going to be one of the most important pieces of Indian law litigation we'll see in our lifetimes. Indeed, I think there's an argument it will end up being the most important piece of Indian law litigation from our lifetimes. And it came out exactly the way that we wanted. On every single issue, 7 justices of the court ruled exactly the way that we asked them to rule, including not reaching the equal protection challenge and dismissing it because the plaintiffs never even had standing to begin with on that score. Now, if you just read the decision without any context, it might not seem actually apparent that this is a massive case. Indeed, I think future law students, even just a few years from now, may read the decision and shrug, figuring this case doesn't really say anything that wasn't in many other earlier decisions, especially United States v. Laura from about 20 years ago. But in fact, for reasons Bob alluded to, this is a really important reaffirmation of these core principles. There's been almost complete turnover on the court since Laura was decided. The only justice I believe who's still around from that time is Justice Thomas, who was not with us then and not with us now. And after last year's decision in Dobbs overruling Roe versus Wade, the big question I think on every court watcher's mind has been, is Dobbs an outlier? Or is this new court open to reconsidering its precedent on every single front? Indeed, the other side certainly seemed to think everything was on the table here. They asserted highly aggressive arguments that sought to turn Indian law on its head, arguments that, if they had prevailed, would have threatened most, if not all, of existing federal Indian law and policy. This was, in other words, at least in my view, a case about the constitutionality of not just one of the most important Indian laws, to be sure, ICWA, but also about the constitutionality really of all of federal Indian law. And the court roundly rejects the arguments on Article 1 grounds, reaffirming that Congress does have the authority to act broadly to fulfill its trust obligations to tribes and Native Americans, including in the area of family law, and including outside of Indian country and state court proceedings. Equal protection, meanwhile, although the court does not reach the merits of the equal protection issue, the signals we do get there are still encouraging. To be sure, Justice Kavanaugh writes a concurrence suggesting that ICWA poses an equal protection problem to be resolved in a future case where a plaintiff has standing, but no other justice joins that opinion. Moreover, the dissenters, Justices Thomas and Alito, notably do not invite future equal protection challenges. They easily could have, at the end of their opinion, said something like, well, although the court upholds this law on Article 1 grounds today, it could still be struck down in the future on equal protection grounds. They, in fact, actually don't even mention the words equal protection in their opinions, at least as far as I can remember, and as far as Control F can find when I open up the opinion. And even Justice Kavanaugh's concurrence, I'd say, actually has some good news on this score. I'm not going to say I like the opinion. I certainly do not. But again, the petitioners asserted arguments that would have had the effect of flipping the court's Indian equal protection cases on their head. The plaintiffs asked the court to treat Native American preferences as presumptively racial rather than as the political classifications that they actually are. And Justice Kavanaugh does not indicate an appetite for that argument. To the contrary, to the extent he suggests ICWA violates equal protection, he says it might do so under the court's precedents, the ones that already exist, implying that he would leave the fundamental Mancari framework in place. And that approach of leaving the court's court cases undisturbed comports with the majority's analysis. The majority opinion, although not reaching equal protection, shows a strong distaste on the Article 1 score for arguments that call into question or cannot be reconciled with its plenary power case law. That's a good sign for Mancari. I think it would be very odd for the court to say in 2023 that Congress retains extremely broad Indian affairs powers, and then for the court to turn around just a few years later and say, oh, actually, even though Congress had the power to pass all these laws, they actually violate equal protection. I think it's very unlikely the court will do that. So at a high level, what I think what we could take away from Brackeen is that the court has all but shut the door on arguments that attack the constitutionality of all of federal Indian law and policy. Now, to be sure, I agree with Paul, there will continue to be questions about whether a particular piece of future legislation or a particular application of a certain law falls within Congress's power and comports with equal protection. And I'm not sure how the court will answer those particular questions when they come up. I'm not even sure what statutes they'll be, what context they'll be applied in. But compared to what was at stake in Brackeen, such questions will be on the margins. And the constitutionality of the core of federal Indian law and policy, I believe, I hope, and I really do believe, is now settled for a long time to come. Indeed, I am cautiously optimistic that the court will not seriously re-entertain arguments about the core constitutionality of Indian law for at least 20 years and possibly even for 50 or more. So that's my big optimistic take. And sorry, I went on for a bit, but very excited about all of this.
And you should be excited. I agree. I think that if you had to take one takeaway from Brackeen, woohoo! They were inviting to blow up Indian law, and the court pretty resoundingly rejected all of those arguments. My predictions before the case dropped was that we were going to lose some provisions of ICWA. I just didn't see a path forward where it was going to stand on all four legs, and it did. And so I think that's amazing. To Paul's point, though, that there were some nuggets in the opinion that I found to be interesting. The equal protection one's the big one, right? That that it was dismissed on standing. It should have been dismissed on standing, but it remains this dark cloud out there. And particularly since we haven't had the affirmative action case yet, I mean, I think this court has been pretty vocal about their eagerness to engage with these issues. And so that to me seems like a big invitation. Nevertheless, to Lenny's point, I think that this decision is incredibly vocal about the court's disdain for these types of arguments. This thing that we should be holding that Congress has anything other than plenary power was pretty resoundingly rejected. Of course, that means that once again, we're in this really awkward position where in order to defend Indian law, we have to defend that Congress has this robust colonial power over tribes, there were some little spots where I think the court used and really leaned into this plenary power as a component of the sovereign to sovereign nation with tribes. And I know we're not talking about it, but coupled with the Lac de Flambeau case, which held to abrogate tribal sovereign immunity via the bankruptcy code, I bring it up only that the court also there was vocal about tribes as governmental entities. And there was this debate about whether tribes are wholly domestic or wholly foreign, and that they're both, and we're still trying to navigate this. The other big takeaway for me was this side debate that Justice Gorsuch and Justice Thomas seem to have relitigating Castro Huerta in their concurrence and dissent opinion. And to me, that remains something that needs to be monitored. Castro Huerta was the case last term that held that states enjoy and always have, at least since sometime in the 1880s, concurrent criminal jurisdiction over non-Indian offenders, even for crimes committed against natives on tribal lands. This was a massive shift in Indian law, and they seem to have been relitigating the extent to which tribal sovereignty is in this. Is it foreign or is it domestic, which impacts, from Justice Thomas's views, how plenary power should be exercised. I think in the days of Laura, Justice Thomas was an outsider. His views on federal Indian law were totally unique and fringe. And that's still true now. He's still writing this dissent. But given Castro Huerta and the fact that a majority of the court did sign on to that, this debate all of a sudden seems a little bit more serious. And then, of course, Justice Gorsuch's concurrence brought up a lot of incredible framing that I think, all of Indian country, our hearts really beamed at. But it's worth noting his incorporation of the history of Indian child welfare, the boarding schools, the Indian Adoption Project, that wasn't really addressed in the majority opinion, though the majority does note the importance of Native children to the survival of tribes, which was great. He goes into this whole origin story of the plenary power, which Justice Jackson and Justice Sotomayor do not join, which I think is noteworthy. And so I just want to note there that, like, I think Castro Huerta remains this this aura that's hovering around Brackeen and informing potential battles to come.
I appreciate that. Thank you guys for sharing your initial reactions. And I'm sure our audience has their own reactions. And so I wanted to take a time right now to remind everyone that we'll be taking questions toward the end of the program. So please use the Q&A function to get in the queue. And with that, I'll go ahead and go to Bob. Bob, I want to ask you, would you be willing to share your thoughts on this court and what the decision means to you with respect to the court more broadly?
Absolutely. Indian law reigns supreme. I guess I said this case was a great victory, but I'm now talking about the court really since Gorsuch joined the court. Now, most of you are younger than me. Of course, I graduated law school in 1991. So I lived through the Rehnquist, Scalia, and Thomas court when tribal position lost 80% of the time, folks. I'm sure many of you remember when NCAI and every lawyer in the country was advising their tribes, stay out of the Supreme Court, work with Congress, lobby, try to avoid litigation. And if I remember correctly, the Roberts Court early on, the tribal wins were 1 out of the first 10 cases. So we are used to losing. And so Gorsuch joins the court. NCAI and some other tribal groups were cautiously hopeful, since here's a judge from the West that has sat on a lot of Indian law cases. I may have my numbers wrong, Derek, but I think that he has now been on the court through either 12 or 13 cases, and he's only voted against the tribal position 2 times. So he's been on the court since April 2017. Justice Barrett, we all talked about, she had no background in Indian law. We wondered what her thinking would be. Again, my numbers might be off a case or 2, but I believe she's sat on 6 Indian law cases now and voted 4 times the pro-tribal position and has written 2 of the opinions. I was concerned about this child welfare case when 3 of the justices have adopted children. So, boy, when she wrote the opinion, so I'm just delighted. I'm going to teach con law this year for the first time. I will absolutely be editing this case down and focusing on the non-delegation aspect, which is just a few sentences, it seems like. But of course, I'll be using the anti-commandeering analysis and how this case pushes that analysis forward from the Prince case. And again, these cases I'm not that familiar with because I will be teaching con law not till January. So by then I'll be an expert, right? Lenny, I'll be calling you on the phone for some suggestions, and Paul. But here, let me, let's see, what did I just wanted to say some more of my thoughts. So this court, now my current students and those who graduated in the last few years, they look at me and they go, well, Bob, we always win in the Supreme Court. Why are you afraid of the Supreme Court? Well, I have PTSD from 30 years of Rehnquist, Scalia, and the early Roberts Court. And Lenny, I hope you are exactly correct, but the Kavanaugh concurrence scares me. And yes, you're correct that Alito and Thomas don't mention it, but where do you think they would vote on that? So that concurrence, he goes out of his way to say that. And just because the parties didn't have standing doesn't mean that question doesn't come up again next year. So I'm still very concerned. And again, it's the PTSD of 30 years of us losing most of our cases.
Thanks for sharing those thoughts, Bob. I appreciate it. I want to see whether any of our other panelists want to expand on anything Bob said or add additional thoughts here. Any takers?
I can start off since, Bob, you mentioned sort of some thoughts I raised. And yeah, I mean, I think it would be hard to convince Alito and Thomas to vote with us on the equal protection angle of the case. But, you know, sort of as you also alluded to when you talked about keeping cases out of the court, what's as important as how they vote on the merits is the cases they vote to take. takes 4 votes to grant cert. And if we assume that Thomas and Alito would vote to grant cert on the question, which I think is debatable. If they were really eager, to vote grant cert and hear another one of these cases, I would have thought that they would have said something to that effect in their opinions, and they didn't. And justices, you can convince justices to say, no, let's not grant cert, even if you couldn't get them on the merits. So maybe there's actually room to convince them, as petitions continue to get filed, to not vote in favor of cert. But let's assume Kavanaugh wants to vote in favor of cert and Alito and Thomas want to vote in favor of cert. That's still 3. They need 1 more, and no other justice wrote separately to suggest a problem. Notably Roberts, who is someone who cares a lot about equal protection, and who has expressed, one might say, frustration with federal Indian law as a matter of policy in the 80s when he was working for the Reagan White House. He wrote a memo where he said he basically really thinks self-determination is terrible policy, but he does not join that Kavanaugh concurrence, and he easily could have. And the other thing, and this is, it starts to touch on subjects we're going to talk about more as we go, but part of why this case was so scary to me was because it was this weird, essentially fake challenge to the law, this facial challenge brought in federal court instead of a proceeding arising out of an actual state court dispute where child custody is actually being determined. And they could throw all these crazy hypotheticals at the justices. So what if it was applied this way? What if it was applied that way? Applications that, maybe start to stretch the boundaries of what's rational, even under Mancari, but applications that, as far as we can tell, and never come up in practice. So I think that they're going to have a hard time finding a fact pattern with an issue they want squarely preserved that is a great vehicle for really making the court feel like they need to rule against ICWA on equal protection grounds. In fact, I think they were having that problem. It's not like, I know that the intensity of the focus on ICWA increased after adoptive couple, but there was an effort to take down ICWA even long before that case. In fact, there have been equal protection challenges to ICWA since it was first enacted in 1978. They had all failed. There have been a lot of petitions, cert petitions filed, asking the court to take these issues up. None of them had been granted. It had only been smaller statutory questions that the court had taken up pertaining to ICWA. So, I see Brackeen as the culmination of the other side being frustrated that they couldn't find the ideal vehicle and trying to make one up. And the court said, no, if you're going to bring us this equal protection challenge, this isn't the way you can do it. So now that they're back to needing to find real disputes where ICWA is applied in ways that make a lot of sense, like keeping children with their own families, I think it's going to be hard for them to present the case that really makes the court feel like they need to step in and issue a constitutional ruling. But we'll see. I could certainly be wrong.
A very minor observation. It's interesting because Lauren mentioned Lac de Flambeau, the Coughlin case, and it would be very interesting if Coughlin didn't come out 2 minutes before Brackeen, and what we would be talking about in terms of the Supreme Court and where it's going, blah, 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 blah. I mean, it's sort of an isolated statutory interpretation case. We have one more that you may have heard of, Navajo Nation versus Department of Interior, has yet to come out. So it may be the Navajo Nation will be 1 for 2. So, in terms of whether Brackeen is sort of an astonishing moment of clarity and an outlier, or whether it suggests something more, I'll be interested to see when we have federal common law cases versus statutory cases, because if there's sort of a commonality in these wins that we're talking about, they're treaty or statute based, or they're about Congress's power. When we have a Montana case, we still do not have clarification for 23 years, or 22 years, since Nevada v. Hicks. Does Montana apply on tribal trust land or doesn't it? I don't know. The Ninth Circuit says one thing, everybody else says something else. Castro Huerta is sort of half and half. For every McGirt, we have a Castro Huerta. Yes, there's a preemptive question, involved in a statute, but then there's this sort of off the rails kind of discussion about, the non-statutory place of states within Indian country, and Worcester, what's that? And, whatever, let's look over there. And so, it's interesting. What's going to happen? Will it balance out? And will this be a triumph that is muted? Or does it, as Lenny suggests, mean something more in terms of what the justices are willing to see the place of tribes? I don't know. Buckle up. It will be a very interesting ride. And Lauren, to you.
Yeah, I guess I would only add that I agree with Paul. I don't think we have enough inputs yet. And the debates going on in the concurrence and dissents suggest that the court doesn't yet know itself where it wants to land here. There was a question in the queue about Justice Coney Barrett, especially because she was the author of the majority opinion, as well as being the author of the Genesee opinion. And as Professor Miller notes, she's sort of brand new to Indian law. And so what's she doing authoring opinions on these big Indian law cases? I think, I know there's like a whole science, and Lenny, you probably know a lot more than me about how the sausage gets made as far as who's like assigned and for what reasons. But I do think it's noteworthy at least that she's getting sort of roped into here. And I mean, in both opinions, we get like a win for Indian law, but we also get sort of a quasi-incoherent articulation of what Indian law is. And so I think that's another stumbling block, that where Justice Thomas and Justice Gorsuch have very robust opinions about what Indian law is, and more notably, whether tribes should exist in the future. I think the rest of the court is really watching on the sidelines and trying to figure this out for themselves. And so to me, this is a massive project in educating the rest of the court.
Real quick before we move on, of course, Roberts is the Chief Justice when he's in the majority, gets to make the assignment. And he was in the majority here, so he chose Barrett to write the opinion. I imagine there was a certain amount of, it's not really by fiat, they have to collaborate together all the time. So I'm sure there's a certain amount of discussion about who it makes sense to write it. But the fact that she is a mother of children she adopted, including children of her own race, it could have been a factor. Many commentators believe that those sorts of optical considerations do factor into who they give opinions to. Also, some people maintain that Roberts likes to assign opinions to whomever he thinks is most on the line, because that will ensure whatever gets written sort of after the initial vote still has that vote after the opinion is finished, that everybody who initially said they would vote that way still wants to vote that way, and it sort of keeps the process moving smoothly at the court. One other thing, I do want to underscore that I think tribes should continue to be very cautious about going to the Supreme Court, very cautious about going to the Supreme Court. My advice to tribal clients 9 times out of 10 is going to continue to be, do not affirmatively take a case to the Supreme Court. And I think that Paul's suggested differentiator between constitutional and treaty cases and these more common law type cases like Montana, where the court sort of has less congressional indication as to what Congress wants, is very much a line that could prove to be a good predictor of how the court will rule. My guess is that the court is comfortable letting Congress make these decisions, but if it feels like Congress is sort of punted and the court is left to make the decision because no one else is left, then it ends up turning more on policy preferences. And I think there are at least 5 justices who are often not with us on policy grounds. So those are especially dangerous cases.
I appreciate your insight. It's always really fun for me to listen to folks like you guys. Lenny, I want to stick with you for a minute. As an attorney with the added perspective of having served in tribal leadership, can you share with us what the Brackeen decision means for tribes?
Yes, happy to. So I was going to use this analogy too when the poll referenced, which is the idea that tribes can now breathe easier after Brackeen. I was thinking about how to answer this question, and it's hard to do it better than Gorsuch did. I mean, his is the rosiest view, but I think that this particular language cannot be emphasized much. He says, in affirming the constitutionality of the ICWA, the court safeguards the ability of tribal members to raise their children free from interference by state authorities and other outside parties. In the process, the court also goes a long way toward restoring the original balance between federal, state, and tribal powers the Constitution envisioned. Often, Native American tribes have come to this court seeking justice only to leave with bowed heads and empty hands. But that is not because this court has no justice to offer them. Our Constitution reserves for the tribes a place, an enduring place in the structure of American life. It promises them sovereignty for as long as they wish to keep it. So, great news on all that front. That said, and now we're sort of starting to finally wrap back around to comments we've made, but I think tribes should remain wary of the Supreme Court. The court may not be interested in flipping over the entire table of Indian law, but there are still many hard fights ahead. Let's not forget, for instance, that on the same day, as Lauren and I think Paul has also mentioned now, on the same day we won Brackeen, we suffered an unfortunately pretty resounding 8-1 loss in Coughlin. And now the bankruptcy code abrogates tribal sovereign immunity. And although I do think that future cases are not going to be as high stakes as Brackeen, they're still going to be very important fights and ones that could be very close, like last term's Castro Huerta.
Thanks, Lenny. I appreciate those thoughts. I know my other panelists have also worked with tribes in pretty close quarters. So I want to see whether or not you all want to offer your own thoughts on what the decision means for tribes as well.
Bob or Lauren, I got a couple of things, but I can defer to you and tell them.
Go ahead. In my opinion.
Yeah, thank you. Very quickly, shout out to in-house counsel. One of the things we do every time a case comes out is make the rounds and through memos and presentations and otherwise talk to our clients who are directly affected by these things. Our ICWA program, one of the largest and yet still under-resourced. I think we compete with the Cherokee Nation in terms of the number of ICWA cases out there in all the 50 states. As of right now, there's not going to be an external obstruction. There's always going to be a challenge. The sheer number of kids out there and the dearth of available foster families and adoptive families within the tribe. And so to me, it's a call to arms. They ain't going to stop you, but right now, today anyway, but we need to shore up our internal resources and we need to implement ICWA to its fullest. And that means a whole lot of money, a whole lot of staff, and it means shaking the trees or the rocks or whatever environment you happen to be in and find those foster parents, find those adoptive parents, because ICWA doesn't mean anything if we don't have placements.
Well, I'd like to just throw it, or Lauren, did you have you wanted to say something?
This sort of goes to the next question, but I'll bring it in anyways. I think Paul is absolutely right that that the threats are not going to cease. I don't think they're going to be exclusive to ICWA, but I think that there are also going to be a lot of threats within ICWA work where we're going to see a lot of threats. One of the good things, it didn't outweigh all the risk of Brackeen, but one of the good things is that in being forced to respond to Brackeen, we saw a real coalition build amongst tribes as well as the child welfare world in support of ICWA. For me, there's always been a lot of general ICWA support. ICWA's the gold standard, this type of narrative. But I feel like this was a moment where that really galvanized, that it's no, we are serious. We like ICWA. You had instances, for example, Oklahoma was an original state that was joining this challenge to Brackeen. while they were domesticating ICWA into state law. So you had this split between the attorney general and the actual child welfare practitioners of the state of Oklahoma. And I think you see this across the country, that people actually doing this work both, I think, enjoy ICWA because of the bridge that it builds that is really unique in acknowledging tribes as sovereigns and a need to engage with tribes in areas that impact their interests, such as Native children, but also as child welfare policy. There's a reckoning happening within the child welfare world about what good child welfare policy should look like, and are looking to ICWA as an example of what that world may look like. And so we got not just an incredible brief from tribes that represented a pretty big chunk of Indian country, but we also got amici from other child welfare organizations that I think this sort of reinforcement of allies has been really helpful, and I think could potentially be useful as we forge ahead.
Well, I'd just like to make this point, Derek, if we have time, but in response to both what Paul and Laura have mentioned, the bankruptcy case. Yes, if that had come out first, we'd maybe have a podcast that we'd lost and we'd be sorry. But it was so overwhelmed by what is still, in my opinion, a great victory. And I'd just like to add this about the bankruptcy case. I believe the Ninth Circuit decided in the late 80s that, yes, the Bankruptcy Act waived tribal sovereign immunity. I think there is a split in the circuits. Was it correct? There were two courts that had held tribal sovereign immunity waived and one not. So I guess because that was a statutory interpretation, what did Congress say in exercising this broad power? And because it just was so old, I don't know how to word this without, whatever. The case just did not come to the magnitude of the Indian Child Welfare Act. And then the victory 7-2. So yes, it's so over because it's such a victory. It's just overwhelmed. What does it mean that the bankruptcy issue went against tribal positions? But I hope we'll talk about, and I have been asked by the press, who funded this case and why? And I've heard the name of an organization or two I've never heard of before. And of course, here in Phoenix, we have the Goldwater Institute. Why have they taken this up? And so I just wonder if we want to talk about that at all, or anyone has any inside information to give me some hot news.
I don't think anybody has inside information, but thanks for offering the question.
But I want to hear some gossip, Derek.
All I know is that the press has reported that Gibson Dunn took this case on pro bono.
Despite my direct donation to these organizations, they would not reveal to me. No, I'm just kidding. I'm joking. I did not actually do it.
I mean, I think this is noteworthy in and of itself, that there are organizations that are hesitating to reveal themselves as interested, invested in these cases. And yet we know that they're there. The sheer fact that Gibson Dunn is taking this case pro bono is revealing in their, why would you take this on other than a perception that this is going to be fruitful in future advocacy? And so I think we have enough information, even in the negative, to infer that there is a very sophisticated collection of both law firms and think tanks that are organizing in a very specific way around attacking the constitutionality of not just ICWA, not just child welfare, but the relation of tribes against states. And so I think that, Brackeen was always scary, but post Castro Huerta, I think remains all the more frightening for, as great as Brackeen is, for what it doesn't say. And, it's not a repudiation of Castro Huerta. And this dynamic between tribes and states, I think, is still a very real threat that I think, because of which we are likely to see future cases coming out of this organized dark coalition that currently is in the shadows.
I will say, just as a last minute, Rebecca Nagel's podcast goes into some detail about this. So I would point people in that direction, Bob and others, if you want to know the real scoop, at least as much as she could dig out. It's a fascinating story, I will say that.
Got to download that on your Apple app, Bob. I can show you how to do that later if you want.
I have Android, Derek, so I'm lost.
Paul, I want to go back to you. In your role with the Navajo Nation's Department of Justice, I imagine you know a thing or two about equal protection claims. I wanted to ask you to provide a summary of the equal protection components of this decision, since we've talked about it a couple of times now, in particularly how those claims were addressed by the court and what this likely means for future proceedings in state courts.
Yeah, we danced around it a little bit, and a whole lot of nothing, sound and fury, something, right? I mean, we have been part of this case before this case, because of course ALM is enrolled Navajo, YRJ is an enrolled Navajo. We were involved in the Goldwater Carter case, which was the precursor where the Goldwater Institute attempted to file this in the Federal District Court of Arizona, and even that judge kicked it on standing, went all the way up on a cert petition, if you recall. And so this is not our first rodeo, as they say around here, which just shut down yesterday over here in Winter Rock, Arizona. As you recall, the Federal District Court said this is a race-based statute, period, end of story. Why? Because the second prong of the Indian child definition says eligible, and clearly cut and paste from the Goldwater Institute's amicus brief as to a laundry list of guilty parties who have created race-based membership criteria, first and foremost, the Navajo Nation. Why do I say cut and paste? Because they miscited the Navajo Code in the exact same way that the Goldwater Institute did, believing we don't have actual titles to the code. And there's one code, and apparently there's a section 701, which is one part of our membership statute in Title I of 26 titles, by the way, of the Navajo Nation Code. If you recall, the Fifth Circuit, as I believe Lauren referred to it, the big mess, morass, whatever, even Judge Duncan, you may have heard of him, wrote an opinion that said, well, I'm not sure I want to call it race. It's icky, or, there's some term that they used. It's ickily close or something, but I'm not going to call it, don't call it a comeback. I'm not going to call it race. But what I'm going to say is that there's a rational basis review from Morton v. Mancarry, and the third tier preference, other Indian families, and the Indian family foster care is not rationally tied. So they got you both ways. They can assume arguendo that it's not a race-based statute because we don't want to say so, but then we can say, oh no, but it's not rationally tied to Congress's unique obligation toward the Indians, right? What did the Supreme Court do, as we have suggested? Now, I tend to be more of a pessimist here, but we have a pending case called YRJ in the Texas District Court. So if there's anybody coming for us, it's the Brackeens. Why? They're the party in the case. Mr. McGill, I believe in our vernacular patois in our U.S. Supreme Court, my friend, my colleague, or as we call it around here, Shabro or Shabuddy, Mr. McGill has already been quoted on CNN saying he fully intends to bring the equal protection challenge in YRJ. Footnote 10. One thing I always say, check the footnotes. Some sense there's a real story going on in there. Is it throat clearing, horizontal face punching, or some sort of hidden nugget, as I believe Lauren called it, used for later cases? So what did she say? Footnote 10. Oh, by the way, the Brackeens have standing in a pending state case and therefore can bring this equal protection challenge. Not a whole lot harder to kick a case when you know there's another pending case where they can come right back immediately and make the exact same challenge. So Lenny probably has more insight as to the potential horse trading, metaphorically speaking, going on that may have led to the result of saying, we don't have to touch equal protection, go over there. If you recall, Justice Kavanaugh cites directly footnote 10 of Coney Barrett's majority opinion. Oh yeah, you over there, whoever you may be, Brackeen, state of Texas, there's a pending case that you can bring this case up in. So whether it may be over for some, it's not over for us. For the Navajo Nation, we have a direct target on us in a case involving a little Navajo girl. We lost the first one, ALM. He was adopted by the Brackeens. We now have a little girl that we have been fighting with the Brackeens about basically the entire time this case has happened. Now, if you recall, the standing arguments below were, wait a minute, they didn't even try to adopt YRJ until after the amended complaint. Don't you define standing based upon your amended complaint? Answer, yes. That's not why the U.S. Supreme Court kicked it on standing. If you recall, they said redressability for the individual plaintiffs. You didn't sue the state judges. Hello, McFly. If you had pled the case a little different, that might be different. Hint, hint, hint. And then what about Texas? Oh no, you can't sue the United States Prince Patriae, special solicitude. What's that? There was some interesting academic blog writing on the margins of the sort of arcane standing discussion. Why in the world did they have standing for Article 1 and for the 10th Amendment? Do we know? There's a footnote 5 in Coney Barrett's opinion. Well, since Texas has standing for anti-commandeering, who really cares what the plaintiffs do? One in, all you need is one party to have standing. Okay, but why was there redressability? I don't know, you don't know. Which is to say that this case, we've looked at this case somewhat as an equal protection issue, and we primarily pled it as an equal protection issue, not just because we were involved with the Brackeens, but because the lower court directly attacked the Navajo Nation's membership criteria and said that is the sort of paradigmatic example of a blatant race-based membership definition. Now, obviously, we disagree with that, and we can talk about it, but it is to say that, yes, it carried the day. It may very well be, as Lenny suggests, that means that their appetite for wanting to have this come back on equal protection is somewhat muted, and they can ignore it for as long as they want and never take it up again. But it does mean, at least for the Navajo Nation, as a direct party to the very state proceeding that two justices and, mind you, in the majority opinion in a footnote that everybody seemingly agreed to, is directly involved in part 2, the revenge. We still believe this equal protection issue is a serious one. Obviously, there are various ways one can argue it. We don't know what's going to happen, but it's out there and it's a serious one, and it can come back. And so we have to be vigilant, celebrate great, wonderful, astonishing, astounding victory that protects Indian law for a very long time, but there is that equal protection issue still out there. And if you recall, one other thing I'd like to observe, even among the amici and the merits briefs on our side, there is a broad spectrum of belief as to how to argue the equal protection issue. There is the argument that Indians are in the Constitution, therefore it is automatically immune from any judicial review because it's essentially a political question. Then there are some people who say Indians not taxed is an exemption from the 14th Amendment, so why do we care about equal protection at all? Then there's the, well, Morton v. Mancarry says what it says is a matter of precedent. That means all Indian classifications are political regardless. And then there's the, no, let's look at ICWA's definition. It's tied to membership in both prongs. That's sufficient. You don't have to comment on anything else. So if this comes back up, even among the loyalists, if you will, there is a broad spectrum of approaches, and which one will carry the day, if any of them, remains to be seen.
Thank you, Paul. I always appreciate your ability to add color to your responses and getting us on the same page. The equal protection issue is definitely something the Indian country has been watching. I want to see whether or not others from the panel want to respond to anything that Paul said or offer additional thoughts here.
Yeah, I just wanted to agree all of that. In the opinion regarding like that there's no standing to discuss the equal protection, they don't say equal protection as to whether the statute, which is aimed at Native children, violates equal protection. And they don't even say it's, you know, assuming that Morton v. Mancarry is like good law that we're not going to throw out, and we want to just look at the eligibility portion in which ICWA extends coverage over children that are not yet enrolled but eligible for enrollment, which some have targeted as vulnerable to equal protection. They specifically address the placement preferences as a potential violation of equal protection, which I thought was super interesting because here, like the argument is that it's a violation of like the best interests of the child, so the child is an injury. But what they really mean is that this is a violation of the non-Native prospective adoptive parent's right to have a priority placement that isn't just, I forget the term the court uses, like last standing or lower rung or something that effectively ICWA puts them in an inferior role. And they're clearly really upset about that. So I just thought it was interesting that it was akin to what we see in the affirmative action case, that ICWA is unfair because it punishes prospective non-Native parents, not necessarily because of the harm to the Native child, which is just interesting.
Well, the only thing that I would add to this is a case that I looked up and was going to read again more carefully today. But back in '96, I helped a tiny little bit on a California Court of Appeals case. It's the Ross baby, Inre baby Ross, I think. And I think they were, many of you may be far more expert on ICWA than I am, but I think they were making a kind of original argument then about the child's equal protection right and constitutional rights to then be adopted into a stable family. So if I didn't say this clearly before, the Kavanaugh concurrence scares me, and I certainly think he has Alito and Thomas's vote. And where does that leave Roberts? So that's about all I have to say on that point, but I'm afraid we're going to face this again.
I'll just emphasize a point that Paul made, not one of his primary points, but a point he did make, which is appetite matters so much at the Supreme Court. They pick the cases that they're going to hear, and there are way more things they would like to rule on than they can rule on. Bringing down the Indian Child Welfare Act doesn't strike me as something that 4 justices are super eager about, especially after reading this opinion. I would be very scared if Roberts had joined Kavanaugh's opinion. I'm very encouraged by the fact that he did not. In fact, on equal protection, Kavanaugh was an extremely difficult vote to try to get because he wrote an amicus brief in Rice v. Cayetano, where he basically presented a lot of the same equal protection arguments that we saw from the Brackeens. They kind of lifted them wholesale from Kavanaugh himself. So, what a lawyer says in their briefing does not always reflect what they actually think. Nevertheless, it seemed like an uphill battle to convince that justice in particular of our position. But that he's the only one who takes the time to specifically say, I'm concerned about equal protection. The guy we knew had taken the time to write about this before in an amicus brief capacity. And those tend to be the cases where lawyers are most passionate because they tend to be getting paid less or even nothing to write those briefs. It's great. I think it's great that he's the only one who singles this out. Also, on the standing point, I think, Paul, you may have briefly mentioned the point that Barrett, I believe she writes, and the people here who've been sued are not, for instance, state judges. I don't think they could get around their standing problem by suing state judges. I think a case from a couple of years ago, Whole Woman's Health v. Jackson, pretty much shuts the door on that avenue. So I think they're going to really be stuck with litigating these in the actual child welfare proceedings that arise. Now, those still arise every day, and you're absolutely right, Paul. Your battle's not done. Matthew McGill has said he's going to raise the equal protection argument in the state proceeding, but we've won against these arguments for decades. Lower courts can't throw out U.S. Supreme Court precedent either. So I think the combination of lower courts being bound by existing precedent, and I could be wrong, but I don't see the Supreme Court doing a whole lot to signal an appetite for another one of these cases. I think we've got a pretty good chance of winning in the lower courts and not seeing this go up to the Supreme Court again anytime soon.
If I could just have 5 seconds on a Sir reply. The other issue is how you reconciled Rice v. Cayetano and Morton v. Mancari, where there's some differences of opinion as to what exactly Rice v. Cayetano says or doesn't say. The other thing is look at Kavanaugh's citation, case called Palomore versus Sidoti, which is a very interesting factual scenario that he apparently believes is similar, where a Florida state judge decided because a white woman was living with and marrying a Black man, that was a relevant thing to consider for child custody, and the U.S. Supreme Court unanimously struck that down. Kavanaugh apparently believes ICWA is in the same category as that particular factual scenario. So anyway, I'm done. Thank you.
I appreciate that. So it seems like we're all in agreement that this is like the season finale of Stranger Things, where we're happy for now, but the equal protection component lets us know that it's not over yet, right? Lauren, I wanted to shift to you, and I want to return and ask for your thoughts on the future of the Indian Child Welfare Act, in particularly whether you foresee the same concerted efforts from folks that oppose ICWA, or whether or not you think there's going to be a strategic or philosophical pivot from those folks that oppose ICWA in courts.
Yeah, I think we've touched on this a little bit. I don't see the arguments going away. I think the extent to which there is a faction of people that perceive any barrier to terminating parental rights and slowing the process towards adopting children out as problematic and in need of gutting. So I don't see those going away. But I would reiterate my enthusiasm for our solidifying coalition in preparation to Brackeen. So there was already a cohort of states that had domesticated or enacted their own state version of ICWA. And that's been true for decades now. And that's generally a good idea. If for no other reason, enforcement, just like in the NAGPRA context, within the ICWA context, extremely spotty. It's been like wildly controversial just to even get ICWA compliance on like the basic reporting that that states do to the federal government. And so to maximize compliance with ICWA, putting it in state law, great idea. Some states have gone even above and extended ICWA a little bit into state law. And so to the extent states have used ICWA as an opportunity and a springboard for more engagement with tribes, more robust child welfare protections for kids and families, heck yeah. In response to Brackeen, as this was building up and making its way through the courts, a new cohort of states were like, oh no, what are we gonna do? And like did like some like emergency domestications of ICWA into state law. Great, welcome. I think that Brackeen should be an invitation that we should really be looking for 50 state ICWAs, and then looking to ways in which ICWA was really just the beginning, right? That even before like the 2016 regulations, ICWA was the only statement on what this type of child welfare policy should be, as envisioned in 1978. Since 1978, we have a whole universe of other federal child welfare policies, things like ASPA, that are remarkable in that they're both coming from the federal government, but express very divergent views about child welfare. And so I think there is a lot of work that states and tribes are engaged with as they're enacting their own children's code and working with states. We still don't have things like representation for tribes guaranteed in state court proceedings. We still don't have ICWA notice for non-child welfare proceedings like juvenile justice proceedings. There's some like basic things that I think we can like do like ICWA plus on, but I think there's also opportunities for a more robust envisioning, say from a tribal perspective, what do we want our child welfare proceedings to look like? ICWA never applied to us, but to the extent it expresses some good ideas about what child welfare should be, while the federal government is expressing some other ideas, where are we gonna land here?
Appreciate that, Lauren. Any of our panelists want to respond to anything that Lauren said or offer their own thoughts on the future of ICWA?
I concur with Lauren's comments in full. Thank you.
I definitely agree that the challenges are not going to go away, although I'm optimistic about, the broadest challenges being largely dead in the water. Places where I think we should be especially focused going forward are cases involving application of the second prong of the Indian child definition cases involving voluntary as opposed to involuntary proceedings, and cases involving the third placement, adoptive placement preference for other Indian families. Those are the areas the other side stressed. Those are areas that got the most attention from justices at argument. So I think there's a very good chance the next time we see ICWA before the Supreme Court, it will concern at least one of those three scenarios. So tribes should make sure that they're relying on ICWA in those situations and using it in those ways only when it really makes sense. If we get a fact pattern where the court thinks, for instance, that a tribe is getting in the way of what the parents want, what the state says is the best, yada, 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 the tribe needs to have a really compelling story as to why it views the interests of every other interested party in the proceeding as wrong, and why it's insisting on a different outcome. Or else I think the court is going to be inclined to rule against us. I think facts matter immensely in these cases. I think Coughlin, for instance, the bankruptcy case, was such a bad loss because it was a very bad fact pattern. In theory, how the court interprets that statute is a pure legal question that doesn't turn on facts, but those were awful, awful facts about a man who claimed that he was driven to committing suicide because a payday lender was trying to collect from him. These are the sorts of fact patterns we need to keep out of the Supreme Court in every context, but especially in ICWA. We want to make sure that the way this law is applied is a way that we would have up on the New York Times and be proud to say, look, doesn't this make so much sense as a matter of policy? Isn't this what at least a large percentage of Americans can agree is a great outcome for the child? So that's in order to keep ICWA safe, we should always keep that in mind.
Anything to add here, Bob?
No, I think not.
All right. Well, I appreciate you all's insight here for sure. I want to pause and remind our audience to provide any questions they might have for the panel using the Q&A function on your screen. So this question, I'm going to go to each of you as well. And I'm going to ask generally for you each to share in your opinion, what went right for Indian country in order for us to get this victory? What did we learn from the litigation moving forward? Any takers to go first here?
Should we go by age?
I saw Paul's hand first.
Yeah, Paul, you had your hand up before me. Yeah. You go first.
That's right. Okay, well, I can defer to seniority if that's what you want, Bob. But no, I think Lauren touched on it. The United Front, the coalition, the work. I think if anything, the other side realizes that whenever they're going to do this, they are in for a big fight. And they may have struck first in the prior situation, Goldwater, and arranged and united their group of people and however they're funding this, but they now realize that it's not going to be easy. And I think I would be remiss if I didn't give a shout out to Lenny and all of the group at Jenner, Kate Ford, obviously, the people at Kilpatrick, who shepherded this case and did the primary work as parties in briefing. We were a party, as has been mentioned, as well, but the Amicus Coalition, the NARF Supreme Court Project did an excellent job, Dan Lorenz and others, Joel West and other people, Melody, in organizing the Amicus support and making sure that there was a nuanced but consistent message. I think Lauren mentioned not just tribal interests, but also child welfare interests, Casey Family Foundation and others. The ACLU is involved. I mean, I do think that is what went right. Obviously, Ian did an excellent job in oral argument, right, which was a very, very long, excruciating oral argument, and it had to go last, which, is never a good, except for the Matt McGill begging for a reply where the Supreme Court said, oh, yeah, that's right, you do. Anyway, yeah, move it along, right, that. So to me, I think it's just whatever we may have on the margins in terms of differences as to strategy and approach, it all came together in one voice on the merits to, I think, facilitate this great win. Thank you.
Well, I was pretty much going to say the same thing. Fantastic tribal and organizational effort, the support of all Indian country. I find this kind of interesting. Why is Goldwater and these other institutes going after ICWA if what their real target is to change us to affirmative action, to turn Indian law into affirmative action and use this equal protection argument? I think they thought they could target little kids, have a real sympathetic party, if you want to use that word, in front of the court. But yet also that and our future is what drove just all of Indian country to support this case. And so we had experienced and brilliant attorneys. But this is the future of Indian country. And I want to say something I've only thought of recently. I bet every one of you have thought of it already, and you're going to go, okay, Bob, be quiet. But why do countries worry about their declining birth rate? Why is Japan so worried about their aging population? And China, I guess, now has twice changed its one-child policy, and now it's even more than 2 kids, I guess. And the United States is talking about this, an aging of our population. Well, this is what colonialism tried to do to American Indians, to Native peoples. We know it was genocide, and to take our children, kill the Indian in them, and save the man. And so I think there's a lot of realizing how important our future is, our cultures, our governments, our peoples, is preserving our children. And it seems like the rest of the world's kind of waking up to it as they face declining birth rates, and every country freaks out about it. So I think Indian country got really behind this because we know how important this is.
Thank you, Bob. Lenny or Lauren, you want to jump in here?
I can go next. Neither of us has to disclose our age. I don't know that I have much to add beyond what Paul and Bob said, but I will perhaps be repetitive, especially of Paul's list. But I think what Indian country did right is it recognized the stakes, and it came together to present the Supreme Court with arguably the best tribal advocacy the Supreme Court has ever seen in an Indian law case. And I don't mean to just toot our own horn at Jenner. I will selfishly say, we worked very hard on this case, and we're very proud of the work that we did. And I personally was especially impressed by the efforts of Keith Harper, who recognized the importance of this case from the beginning and has been leading the Cherokee Oneida Morongo portion of this defense for over 5 years. And, other people have already stressed the advocacy that Ian presented at oral argument in November. I wholeheartedly agree with that. But it's also a lot more than that. And it's always dangerous to give thanks and credit in an effort like this one, such a massive effort where the magnitude and the number of people who made significant contributions easily numbers in the hundreds. But, I have to give tremendous credit to Kate Fort, who was our co-counsel and our ICWA expert in this case. I truly believe we could not have won this without her. Navajo Nation was with us every step of the way, especially Paul, who worked tirelessly on this case. None of this was possible without the foresight and leadership of tribal leaders, especially the tribal leaders of the intervener tribes. And as other people have also underscored, the amicus effort led by the Tribal Supreme Court Project was tremendous. Again, the greatest I think we've ever seen in an Indian law case. And I'm going to illustrate. Here is the briefing from Brackeen. It is, it's bigger than a case book. It's massive, massive amount of briefing. I believe there were 21 amicus briefs on our side, dwarfing the 8 on the other side. And even with that many pro-tribal briefs submitted in the case, every single one made a substantial contribution to this dispute. And as we go forward, again, we have so much that has been written now about why ICWA is constitutional. When these cases, because the challenges are still going to be there, when these cases come up again, equal protection ones in particular, anyone who's litigating them should pull liberally from all of these resources to the extent they're not lawyers themselves who contributed to this. But we have so much that we can just copy and paste now. I know Paul was giving Gibson done a little bit of a hard time for copy pasting. Copy paste and then edit. Don't just trust ChatGPT. Check the work, but it's a great starting place for all of this work. And also, we've got this strong, committed network of people connected or committed to ICWA's protection now, and who are ready to spring to notice. So, when these cases come up, there's no need for a tribe to act alone. If you've got a case where there's a serious challenge, especially if you see someone like Matt McGill at Gibson Dunn, or the attorney Mark Fidler, who's often on the other side of these issues, or any major expensive law firm really involved on the other side, like, bring this to the attention of the people who worked on this case, bring this to the attention of people like Kate Ford, so that we can make sure we're there from the start to present the best defense that we can of law.
Here. I would merely reiterate the power of coming together as Indian country. This isn't the first case in which this has happened, but it certainly underscores how important it is. And I think it is certainly the most robust version we have of this type of collaboration. It's always been so difficult because tribes are separate sovereigns and yet treated as a monolith. If there is an Indian law holding, it applies to all tribes, regardless of what level of participation was involved. And so I think what went right was, as Lenny said, a recognition of what was at stake and bringing together our best and brightest. And in the course of doing so, identifying like who those are, and for interested allies, how to engage in a meaningful way, which is really, really useful. I was typing answers in the chat, for which there are really, really good questions. Jennifer Weddle brought up this quandary from Justice Barrett about the need for a rationalizing theory. And I think that was a really good question, in part because I think Brackeen is also reflective of a slight pivot in the court from approaching Indian law as this quirky stepchild, that it's oh, it's an Indian law case. We get to bring out our very idiosyncratic, exceptional case law, to an interest in really diving into what these doctrines are and how they engage with the rest of the law, which is really, really scary and really risky, but I also think is really potentially beneficial. This was some of the first cases where I saw, particularly Justice Gorsuch, but other justices as well, talking about the future of Indian country and the future of tribes, which to me suggests not just we're not going to just be assimilated away, but also a recognition of what Indian law means for the rest of American law. And so I think that that's a potentially useful invitation as we have grown in our sophistication with working together.
All right, I appreciate your answers for sure. I want to go ahead and move over to our Q&A portion of the agenda. As Lauren signaled, we have a lot of good questions. Real quick, Sheila wants to know who besides Justice Barrett has adoptive children. I believe it's Chief Justice Roberts and Justice Thomas has adopted his nephew. So those are the three justices with adopted children. One of the questions that we have is from Sean Adekai. Paul, I'm going to kick this one to you because Sean asked, what degree, if any, is the Brackeen decision foreshadowing the Navajo Nation water rights case that's presently before the Supreme Court?
Hey, Sean, what's up? By the way, I want to give a shout out. I noticed when you look at the list, there's a whole lot of Diné on here. So, including you, Derek. So just wanted to say yacht A to all the Diné who came out to heckle me. But it's a good question. I mean, as we said, it's a very different case, right? It doesn't have to do with constitutional challenges to statutes. Has to do with what is an enforceable trust right. And as you know, as has been briefed, our treaty plays a very prominent role in the discussion and the presentation. So I don't know personally, and I don't want to predict because I will be wrong, Maybe Lenny has more tea leaves to analyze, but I will say I hope it means that the right people are making the right conversations within the court to have a much more nuanced, as we say, forward-looking approach. Because of course, our case is forward-looking. The nation needs water. The nation's people need reliable water sources. The United States need to give it to us. Thank you.
Appreciate that, Paul. Go ahead, Lenny.
Let me just say, I don't have any special insight on that one. Yeah, it's hard to predict where that one's going, but I'm hopeful. I definitely think it's winnable. We'll see what happens.
Anybody else want to weigh in on Navajo v. Arizona?
It would be crazy if they found that there's not an obligation to quantify these water rights, and particularly in the context of like the river and the negotiations that are going to have to take place with the dwindling amount of water, like here in the Southwest, like it would be completely out there. Now, it wouldn't be out of line to have a crazy decision in Indian law. And I could see a world in which the court buckles to the pressure of that, the needs of climate change are just too much. We can't accommodate these types of water rights that we've never bothered to articulate in the first place. But that's simply like wrong. That's just not how we're going to get our way through this. So I'm optimistic. But if we get a different decision, there's probably going to be another webinar.
Appreciate that. And I'll say opinions come out on Thursday morning. So this could be in the next batch of opinions this Thursday, and we could know sooner than later the answer to that question. I will say that actual case is not about the merits. It's actually whether or not the tribe can bring a claim in the first instance in the Ninth Circuit. That being said, we have another question about whether or not ICWA is a call to action for tribes to reevaluate how they do their enrollment. In other words, moving away from blood quantum. Anybody want to pontificate here?
I don't know. It's hard to say how much moving away from blood quantum would moot these arguments, as long as tribes continue to use descendancy in some way, shape, or form. And I haven't personally seen a lot of appetite for moving away from having some sort of descendancy requirement. But the plaintiff's arguments here did not talk about blood quantum much. They focused a lot more on descent being a proxy for race.
Go ahead, Bob or Lauren. I obviously have an opinion about this, but go ahead. I want to defer to you guys first.
I think that, I'm sorry, Bob, go ahead.
Well, we know, of course, blood quantum, the idea came from the colonizer who wanted to bleed us out. So the blanket Indians would turn into little, I better watch how I speak. But over 20 years ago, I taught a couple of clinical classes when I was an adjunct professor, and I had my classes try to draft tribal enrollment ordinances that did not rely on blood quantum. So, people have been thinking about this for quite a while, but yeah, how do we back away from that? That's, so I didn't give any answer at all, did I? I just complicated the question. But Lauren and Paul, what do you think?
I think there are a lot of reasons to think about and debate blood quantum, but in this specific case, I don't know if it's necessarily the blood quantum that's issue. To Lenny's point that there'll be descendancy, I think where a lot of the concern was in leading up to this case was as I noted earlier, the extension of ICWA to enrolled members versus those that are eligible but not enrolled. Similarly, the federal definition of Indian is broader than just those that are enrolled. And so I see some of the issues about how we define Indian to include a broader group of people beyond just enrolled members of tribes. But amongst the enrolled, I think that's a different issue.
Just very briefly, as an attorney for the nomination government, I cannot comment in an official manner as to what the nomination should or should not do. Paul Sprung, the academic, may have written quite a bit about this particular subject. So Social Science Research Network.com, look it up. But I will say, without revealing anything that's attorney-client privilege, this case has caused an internal discussion. Now, whether it will lead to anything, there was one attempt, and this is a matter of public record, and I believe the last council, to change at least part of the enrollment criteria to go beyond, not get rid of blood quantum, mind you, but go beyond blood quantum to allow on a case-by-case basis in certain situations where there are closed adoptions and otherwise you simply can't prove up the 1/4 blood quantum through documentation. That failed. It failed very significantly in the nomination council. There's a lot of debate about this and other subjects, whether it's subject to a referendum by the Navajo people, or if it's something that the nomination council can or should look into. I will say, again, look it up. The nomination passed its enrollment statute in 1953. It has never amended it since. So 70 years ago was when the Navajo Nation first, and the only time. There was no enrollment statute before 1953. There has been no amendment to the enrollment statute since 1953. Demographics as it is, traditional fundamental law, Deneba Behenos Ani, Planship, all these concepts, how it will enter into the mix from the purpose of the Navajo Nation. I'm just an observer. I'm in for the ride. It is for up to people like Derek and others on this call to decide that question, either as elected leadership or as voters on the Navajo Nation. Thank you.
I appreciate that. And I appreciate everybody's questions. I'm sorry we couldn't get to them all, but I do want to do a quick speed round of final closing thoughts. And on my screen, I have Lauren, Bob, Paul, then Lenny. So let's go in that order. Quick closing thoughts.
I'm so grateful for all the people that led us to a resounding victory. Congratulations.
A wonderful victory. Now let's get ready for the next challenge.
Rock on, fight on. Thank you.
Congrats to everyone. Let's celebrate, but not let our guards down.
Well, I want to give a hearty thanks to each of you today and provide thanks to our audience for attending. We know you have a choice on where and with who you spend your time with, and we appreciate you tuning into our presentation today. We hope it was informative and thought-provoking. I'd also like to remind you that the link to the CLE materials is in the email you received to join this webinar, and it will also be emailed to you tomorrow. This webinar was recorded, and the link will also be emailed to you in a couple of weeks. Thank you, and have a great day, everyone.